taken care of in our concept, in fact. And then we also feel that there are certain things which have been misunderstood. In fact, India is not simply a parliamentary democracy. It is a Republican parliamentary democracy with definite role to be played by the President of India. It has elected President of India. Its office is there, who stands aided and advised by a council of ministers. And there are provisions in the constitution which clearly prove that President of India is not a rubber stamp. Because we never wanted an all-powerful president or an all-powerful any officer in the constitution or anywhere in the country. We never dreamed that our president or prime minister should be a person in uniform, etc. No, we believe that they should be great statesmen. They should be able to give leadership to our academic world, to our bureaucracy, to the people of India, and command respect in their hearts. That definitely we want, but our police inspectors and superintendents of police and the majors and brigadiers are the people in uniform to take care of them. So we wanted very sagacious people to hold these offices. Then one thing which we are not simply a parliamentary democracy, but a Republican parliamentary democracy, and there are provisions in the constitution where President of India doesn't need, in fact, aid or advice of the Council of Ministers. He can act on his own also. Then we also feel that there is supremacy of constitution. We are a country, we are a political system which is not having supremacy of parliament, of judiciary, or of executive. Not at all. It's the supremacy of the constitution. Parliament of India is a creation of the constitution. And in that sense, we have two houses. And we nowhere in the constitution it is written that one is lower house or one is upper house. These kind of terminologies have not been used. None of the houses is lower or upper. One is a unitary feature of the constitution, that is House of the People, and another is Council of the States, because our unitary polity is based on federal fabric. So members of states elected by the state assemblies, they sit in council of states, Rajyo ki Sabha, and it has a function of checks and balances on a legislation being done on the union list, mooted by Lok Sabha, but the view of the Council of the States, which of course will be subordinated view to the unitary polity, unitary feature of the Constitution, will definitely be taken care of. So, no house of lower house or upper house. That's the British problem. They had House of Lords. We don't have any lords in our country, and whosoever they were there, they have been shown the way. We have neither House of Lords nor House of Commons. And anybody who thinks he or she is a lord is grossly mistaken, in fact. Both the houses have different purposes. Similarly, we have not used terminology like lower court or upper court anywhere in the Constitution. No court is a lower court. We have, or no court is a higher court as such. Courts are courts. The terminology which we have used is Union Judiciary, that is Supreme Court of the country, and the State Judiciary, that is High Court, and then the subordinate judiciary. That is what is the clear picture in the Constitution. So, the students are required to have a feel of this, that court is a court, and many wonderful judgments have been given by subordinate judiciary in the country, well across a journey of 70 years. There is possibility of time, in fact, for me to go to in those judgments, whether pronounced by Justice Dhingra, whether pronounced by Justice Bharat Bhushan in Thapar bail case, or so many cases are there where a magistrate or a judge delivered that relief which other courts could not do. So we are a Republican, not a parliamentary democracy.
It is said that Lok Sabha is the lower house and Rajya Sabha is the upper house. So the terminologies, as you are discussing, somewhere, why then we use, it is called as a lower house?
In fact, that has been written by academicians in various books by wrong interpretation, by British analogy. But in the document, which is known as Constitution of India, it has not been written like lower house or upper house or lower courts or upper courts, because their role and functions are well defined in the Constitution itself. House of the people and council of states. Similarly, union judiciary, state judiciary, and subordinate. Because if we develop that kind of concept that there are lower courts and higher courts, then the majesty of the court goes, and the relief which we can get from subordinate courts, we will not be able to get.
Very right, sir. Very right. Thank you. Thank you, sir.
Yes. Ji, thank you. So, supremacy of constitution is there. Then one thing which is to be understood, that if a student, somebody asks that how we can define president, vice president, prime ministers in our constitution. In fact, the simple answer is that they are the officers mentioned in the constitution. With their offices, they are given a salary for that, they are given accommodation to live for that, they are given DA, etc. for that, and then the pension after retirement. So President of India, Vice President of India, Prime Minister, Ministers of the Union, and similarly the replica in the state, they are officers prescribed in the Constitution. Officers prescribed and officers prescribed. Here we have to also to distinguish, in fact, the concept of officer and office. The structures, institutions, infrastructures, technological structures and infrastructures are permanent. For example, the office of president is there in Rashtrapati Bhavan, North Block. Now, in that context, there is a nameplate, President of India, equipments there, an office there, furniture there, everything there, a constitution there, the document. That is fine. The office is created. But officer is the driver or the server of that office, the individual who goes to drive that office like a driver or a pilot, or a person who makes that office functional. The better you drive, the better you take off and land without thudding. The history which you create, the footprints which you create in 5 years or 10 years or more or less than that, or maybe within a few months, they are remembered in fact. So those people like Pandit Jawaharlal Nehru, people like Lal Bahadur Shastri, people like Atal Bihari Vajpayee, they have been remembered. People like Dr. Rajendra Prasad, Dr. Radhakrishnan, Dr. Shankar Dayal Sharma, Professor Kalam, they have been remembered the way they drove that office. So office is more important, country is more important, nation is more important, infrastructure and institutions are more important than individuals. Once the human individual understands this, automatically the sublimity comes in the individual. He will perform with great maryada, within well-defined boundaries, and of course, that way he will drive that office better and will deliver better and will be remembered in the history of the country. So that is, again, we have to distinguish that the officers have to understand that the offices they are driving, they are more important than they themselves. And friends, here, one more simple thing I will say. There have been a lot of debate amongst academicians and the law world that whether Indian constitution is federal or unitary. In fact, the simple souls, the sacred souls sitting in the constitution, they had very incisive vision, very affectionate and clear vision. They declare India, that is Bharat, shall be a union of states in Article 1 itself. So we are a unitary polity based on federal edifice. We respect federalism. We respect devolution of powers, delegation of powers and roles. We respect all the concepts of administrative law, which is an extension of constitutional law in every respect. but definitely we wish that things remain under control. There has been a controversy with regard to name of country also very recently, whether it should be India or Bharat or what. In fact, as I mentioned, our culture is global culture. The soul of our constitution is global, universal, and international. We are a culture like that. We are people like that. And in that sense, we required a name as India, a modern name, a name with its historicity, because we do use many versions of India, Indica, Indigo, so many things, because we had been blended with Greek and Roman civilizations also, where our stories, our lyrics, our ballads were traveled in ancient India. We had culture, cultural relations, we had diplomatic relations. Ambassadors of these countries were posted in the courts of our emperor. So we trace our lineage from there on. We prefer to call it Bharat, not as Hindustan or anything else, which may sound a bit religious in nature, because Bharat or the culture or the society at that time was inclusive society. Most of the rishis who composed various mandals of Rig Veda, they were not Brahmins, and quite often they were not Kshatriyas either. To mention great, in very brief, both the epic writers, Vedyasji and Maharshi Valmiki, they were not Brahmins or Kshatriyas. Many rishis. So that was an inclusive society which included Aryan as well as Dravidian civilization on the basis of the great karma based on virtue. That is, duties performed virtuously. Dharma or duties performed virtuously. Karmas performed as per dharma, as per righteousness, not exactly religion. So in this sense, that was an inclusive civilization which included many civilizations, many cultures, had diplomatic relations across the world. We prefer to call it Bharat, not as Hindu or Muslim or any other word. We didn't use that. So in this way, these things are well settled, and a lot of research has been done on these issues, and these debates have been finally settled long back, in fact. So we are a unitary constitution, because constitution itself says we are a union of states in Article 1. And then other simple things which I will mention here. One more controversy on which one line clarification will clear all doubts.
Sir, here I am having a one query pertinent to that what has just been told by you. It is generally the word used is quasi-federal. So will it be appropriate to use this terminology quasi-federal that we have been studying since our school days?
This term has been used, in fact, by scholars. There is no doubt about it. Quasi-federal has been used. Some call it quasi-unitary, and many other things have been said about it. But to my mind, Indian constitution is a great innovation in its own sense. Like, it's not the constitution of America or unwritten constitution of UK or constitution of France or constitution of Southern South Africa or Germany or simply Government of India Act 1935 that it is. In fact, it's an international constitution which incorporated best of the best features of almost all the constitutions of the world. But before incorporating those features, they were well researched, with interactions with parliamentarians, advocates, lawyers, teachers, students of those countries, and freedom fighters also of those countries. And then a composite document was made, well blended to the needs and requirements of our country. So quasi-federal will be a word which will confine the innovations in Indian Constitution in a very limited zone. It's a great innovation, and so many things have been blended in it. In fact, uh, the type of gray matter which has been put in the ethereal, legal, invisible person occupying the throne, uh, as mentioned in preamble in part third of the Constitution, in part 4 and part 4A, that is wonderful and very, very different as compared to one single constitution which may have got. So it's a great innovation, but we respect the views of almost all the scholars of the world because they studied Indian Constitution as their specialization area. So academic views have been conveyed, but to say quasi-federal or any such thing will be a bit um, limiting the scope of the
Right,
or
sir. Thank you.
yeah.
Thank you.
So nice of you for this question, in fact, Ravika. Then,
Thank you.
then we also try to understand one thing. When I call constitution as a legal person, as an ethereal individual, invisible like a robot with excellent gray matter, because human beings don't have the capacity to administer the country the way constitution administers or technology administers due to millions of reasons, in fact. So we call it as, there is a preamble, we call it as soul of the Constitution. The Supreme Court mentioned this as soul of the Constitution. So there is a soul of Constitution also, an ethereal individual with a beautiful soul of this document. Then one thing I wanted to say about reservations, a very debatable topic. In fact, if we just remember that what is the constitutional goal of reservation, the entire controversy gets settled. And unfortunately, this has not been conveyed in rallies, in speeches, and in discussions. The constitution, the constitutional goal of reservation mentioned in the constitution is not poverty alleviation, is not upliftment of backward or classes or weaker sections as such. The constitutional goal of reservation is to, to ensure adequate representation of all the sections of the society, especially weaker. So adequate representation is the important part. What will be adequate, whether it will be 15% or 27.5% or 50% cutoff, that is adequate word is to be determined by the government of the day after approval of the parliament of the country.
Sir, is it true that these provisions of the reservations were made for a certain stipulated time, and after that they were supposed to be removed from the constitution? Is it the situation like this, sir? But because of the political motive, these all these points which have been mentioned in the constitution so far as the reservation is concerned were not removed from the constitution.
Dr. Gupta, you are absolutely right, in fact, in this question. In fact, there was a time limit thought by the constitution makers, or if
Sir,
not constitution makers, then at least the first parliament of the country.
sir, voice is not coming, sir. Your voice is not coming.
Yes, sir. Voice is not coming. Yeah.
Now it is coming?
Yes, sir.
Yeah. Yes, sir. Okay.
Now it is clear.
Right. So, in this context, I will say that the constitution makers thought that they will be able to do this social engineering within a period of 10 years. Perhaps they believe that it will be a very Herculean government focusing on this task, and the adequate representation issue, adequate representation, the government will be able to provide within a period of 10 years from the coming of the constitution. But in fact, believe me, this 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 task, in fact, of social engineering in a country like India with so much of diversity is enormous. it may take not even decades but centuries and millenniums to have the social justice in the country through democratic and peaceful means. But the concern of all of us is the main issue is that the direct benefit of reservation, the DBT must reach to the real needy. So that's why classification within classification, bar on the promotion of, bar on the bar on reservation or promotions, later on nullified by Narasimha Rao government by 77th Amendment. All those have been the political overtones of things. But India needs to have a mainstream, the main line, uh, the main current of all the people with adequate representation to all the sections, to women too, which is long awaited, to ensure that adequate representation and so that the related benefit also goes to the real needy in a DBT way. That is to be ensured, in fact, because it is not going, this direct benefit is not getting properly transferred to the people in need in India. So what I was saying here only is that the constitutional goal of reservation is not poverty alleviation, for which hundreds of schemes of central government and state governments are there, but the constitutional goal is to have adequate representation of women, adequate representation of all the sections of the society
Yeah.
which are not represented.
Yeah, Dr. Sabha, I have a little query regarding this. I'm Dr. N.K. Bahel from Delhi Metropolitan Education, Law College from Noida. Sir, you have, good evening, sir. You have rightly referred to so many values of our constitution. My little query, sir, is that so far as law students are concerned, I'm talking of law students, they have the value of liberty, equality, as well as right to education. And now you have referred to reservation also. So, sir, which value is the most student friendly according to you is the question number one. And related question number two, sir, is whether anybody is allowed to choose any friendly value from the constitution, or is there some norms are fixed regarding the values? Can I choose any value which suits me? Please.
So far as this second part of your observation is that with regard to selection of value by an individual, very humbly stating, sir, as an individual, we can't choose a value in that, because fundamental rights area, the entire part C area, is mandatory area. Like a kid cannot say that a person cannot say that he will not take primary education. He uneducated, he's better. He cannot say I will not have this freedom, or I will not have right to equality, or I will not have right to life.
Sir.
So doctrine of waiver doesn't apply on fundamental rights area, but besides this zone of part 3, the doctrine can apply. We may waive our legal rights. With regard to first thing, which first observation which you are saying, if you can repeat it, sir.
Sir.
The first one. Okay, I will come to that. So you were asking about right to education and other concepts.
Yeah, right to education, liberty, and equality.
Yes,
which is most student friendly. Yeah.
In fact, without equality, without liberty, without life, like these are the three important fundamental rights, education will be meaningless. Because you see, sir, howsoever we educate an individual, there were great scholars in ancient period, in medieval period, and in late medieval period also, and early modern period. Even in present day China, even in the Russia of 20th century till there. In fact, the basic object of human rights and fundamental rights, their nurturing, their protection, their promotion, is to allow an individual to bloom in the fullest possible extent of his personality or her personality. Because the moment we withdraw these values or we do not provide these rights, definitely the personality of the individual gets smashed and he fails to develop fully. For example, if children are kept under too much of pressure inside the home,
Yeah.
if the decision taking ability is not allowed to develop in them, if the leadership skills are not allowed to develop in them, if we very strictly handle in our college or university, then definitely their personalities will suffer. And in the long run, we will find only 2 or 3 Nobel laureates in the list from Russia and other countries of the world in at least post Second World War era. And in the entire list, you will find people from United States of America leading that list. Whether it is land and great discoveries, whether it is the invention of internet in 1986, John Postal or Charles Babbage inventing computer, first email also getting sent in the world in America, and then uh, your landing on moon, decoding of genetic code, Nobel Prize going to Farana, all those people. So it's a democratic, the democratic values in fact help in blooming of the personality. And here I will link up one more thing. It's an excellent observation from your side, sir. One thing which I would like to mention here is with regard to human rights. In fact, I remember when Human Rights Commission of India was also not there, we were fighting for human rights in the guidance of Dr. Bakshi in Delhi University. And many cases and case studies we did, and practical action we took. Now, what I'm finding is from 1995 onwards, the entire human rights movement had receded in the background in a country like India, and that's why we saw these scenes of migration and suffering. And the whole Indian market and economy has been made a casino, in fact, and no talk is going on about human rights, and the whole movement has been defamed by calling it as urban nexus, and also criticizing it vehemently and putting people in jail. So this is what is the situation of human rights in our country. Their human rights movement, we don't have any hints, any lineage now. Very, very difficult situation. I will end here on this point at least, so that I proceed further, because I am on the concluding note of the lecture, in fact, of this talk. And uh, one more thing I will mention here. In quite often in debates recently, we find people saying that this is our fundamental right to religion. One, we must remember, all of us, that there is a worth attached to fundamental rights also across the world and even in our country. That worth gets reflected by the riders which a particular fundamental right is having in a particular provision. And the fundamental right to religion is a fundamental right which operates under maximum rights. So fundamental right to religion cannot be equated to any other fundamental right. Similarly, one more thing for further research by students, the young people, I will give an idea here that of course we introduce fundamental duties of socio-moral nature in our constitution in part 4A, article 51A, on the recommendations of Sardar Saran Singh Committee during Mrs. Gandhi's regime, efforts of Menkaji in 42nd Amendment 1976. Yet, the legal nature or constitutional fundamental duties were already there. For example, in Article 19(1) Clause A, there is freedom of speech and expression. But in 19(2), Article 19 Clause 2, there are restrictions there, which are rights of others. There are restrictions on every fundamental right. So fundamental rights operate under riders, and those riders are in fact our fundamental duties of constitutional natures. Constitutional nature. So all this can be researched further, because I haven't come across.
Dr. Sahab, I would like to ask you at this juncture that human rights are really meant for humans. But if a person is behaving like inhuman, in COVID period, few people are attacking on the doctors, paramedical staff, even on our police officers. Are they also entitled to human rights when they are behaving in an inhuman manner?
They are entitled to the extent which law permits, because ultimately it's the law which gives fundamental rights and human duties. So to the extent uh, they stand protected as per the parameters of law, not more than that at all. Suppose a person is spitting on someone, we can't kill that person as such. We can't shoot that person. We can't put that person to languish in jail beyond the statutory provision. So that's what will be the yardstick in that case.
Thank you,
As,
sir.
then one more thing here, which I would like to share, that I visualize, as I mentioned, Constitution of India as a lyrical poem, as a testamentary ode, as a will of the freedom fighters, as a will of the revolutionaries, as a will of the people of India, unsung heroes of those times, those 2 centuries, because Indian freedom struggle clearly went on for 190 years. 757 Battle of Plassey, 1857 the Great Mutiny, or the first War of Indian Independence, and 1947 India gets independence. So this has been a journey, in fact, long journey, where several generations of freedom fighters got sacrificed and people of India got sacrificed. In fact, what I want to mention something very touchy here. When Constitution was being drafted, there was a generation sitting in Constituent Assembly. If I remind, um, in 1885, when freedom movement gets articulated, Congress gets established. In 1950, Gopal Krishna Gokhale was no more, Firoz Shah Mehta was no more. Gokhale ji had written letter to Gandhi ji inviting him to India, and then Gandhi ji coming. In 1920, when non-cooperation movement was to be launched by Gandhi ji, Tilak died in early hours, and a whole generation, a lot of people dying during freedom struggle. So the remaining lot which was sitting, who were people highly educated also in India and abroad, और पढ़े हुए भी बहुत थे वो लोग और पढ़े हुए भी थे, because they were in direct touch with the people of India. So they had a great worry that people of India have performed their part of contract. We offered them through resolutions every year in INC sessions that India will be like this when we get independence. Several generations are gone, our forefathers have gone, and if those promises are not fulfilled, then we will stand condemned at the bar of history. Offer, acceptance was there from the people of India, consideration they paid, they went to jails, they sacrificed their lives. Then cause was also good, capacity to consent was also there. So they were thinking what to do, how to ensure, because they were knowing that they are on the departing note from this planet Earth, and future generations may not fulfill those promises. So in fact, the help came from the concept of Irish Constitution, directive principles of the state policy, which I really believe from the soul of my personality, that that part of the Constitution is the will of the freedom fighters. WILL, will of the freedom fighters, testament of the freedom fighters. And in fact, that was a great worry of great leaders like Pandit Jawaharlal Nehru, who, on whose table that slip of paper was found. Woods are lovely, dark and deep. I have promises to keep, and miles to go before I sleep, and miles to go before I sleep. Those were the promises people of his stature, his father, and hundreds of colleagues had made in Congress sessions to the people of India. People responded, but they were to be fulfilled, and that's how the mechanism of DPSPs was evolved, directive principles of the state policy. And in that sense, that's a marvelous part of Indian Constitution, where the whole theme, the whole gray matter of the Constitution is raised. And that gave leverage, in fact, to our learned courts, judges, and lawyers to get interpreted the Constitution in a way that the fundamental rights in Part 4, which are in waiting, they also acquire the status of fundamental rights with time to come. And to end, in fact, our Constitution and our culture is not based on any kind of ism or philosophy. whether it is communism, socialism, or anything like that, or Maoism,
Sir,
or
yes, sir. Sir, there is one query that is coming to my mind, and that is that when we discuss this Constitution of India, some student-friendly reflections, though there are many provisions, fundamentalized duties, they are okay. But can we say that there is any provision in the Constitution of India which specifically talks about the friendly relations with the students?
which specifically talks about, Dr. Gupta, pardon?
Student-friendly relations like this, sir. Student-friendly relations.
Okay. In fact, since this constitution did not subscribe to any political or sociological thought of those days, in fact, they developed the constitutionalism, which is based not of any ism of religious or racial nature or regional nature, but but on the higher moralities of law like democracy, like fundamental rights, like human rights, like education, and the fundamental duties subsequently which came in Article 51A. All these, in fact, are so simple. If the student keeps in mind that Professor Mishra has said that it is a lyrical poem, it's a lyrical ode, the halo created around it by professors, the too much of complicated way in which it has been taught and handled by lawyers in courts, and maybe hundreds of vested interests of the bar. Otherwise, it's such a wonderful document which, if a non-law person even reads, then he or she will enjoy it. And I'm very thankful to the learned CM Delhi,
Excellent.
who used 2,500 times this word during the Anna movement, that research which has come out. So he was the first, in fact, to talk about this before the people of India, and then people of India started asking, what is this Samvidhan or Constitution? So it is to be people-friendly first, it is to be propagated amongst people, it should not be in ivory towers of lawyers, and of course with us in simple ways.
Thank you, sir. It was an excellent reply to my question that I put before you. Sir, before the time runs out, I would like to have one question which is coming as a query. And the question is, sir, it is said that the constitutionalism is different thing from the constitution. So can you, sir, throw some light on this word terminology as to what constitutes the constitutionalism? As it is said that there may be the constitution, but not the constitutionalism.
True, Dr. Gupta, wonderful question. In fact, uh, constitutionalism, since I'm delivering a student-friendly talk, is the suffix, wherever it is attached with any word, it becomes a philosophy. Like Hinduism,
it becomes what, sir?
It becomes a philosophy, like Marxism, communism, socialism, Hinduism, Christianism, like that. So constitutionalism is a philosophy. And if it is a philosophy, the inputs of this philosophy or the pillars of this philosophy on which this philosophy rests. For example, Marxism rests on thesis, antithesis, and synthesis, dialectical materialism. That is, those are the three pillars, in fact. Similarly, constitutionalism rests on pillars like republicanism, like democracy, like gender justice, like fundamental rights, like liberty, like freedom, like dignity of individual, like rule of law, like judicial review, which is the oxygen of rule of law. Then all these, in fact, inputs or the pillars, they constitute a neutral, a secular, a universally acceptable philosophy or ism, which to my mind is constitutional. Because when we read the whole constitution, we find these great inputs and pillars on which it rests. So that is what is constitution.
Thank you, sir. Thank you. Thank you. Thank you, sir.
And in the end, if I mention slightly something more, 1 or 2 minutes, then the purpose of fundamental duties which have come in the Constitution is to humanize human beings. That is the greatest challenge which has been there during last 3 million, to humanize human beings. quite often, because human beings are also animal beings. Since they stand socialized, they are said as social beings. So that process of socialization, as there is process of domestication of animals, similarly there is process of socialization for human beings. How good it is, how well nurtured it is, how polished it is, that is important in fact. So these fundamental duties, if they are transmitted to the heart of younger generation, definitely they will stand humanized, and even elder generation. So that is what is the purpose of fundamental duties. Two great things, two great researches which took place in India, and that they came from one from Professor Vin Bakshiji, one of my learned teachers and very respected teachers in Delhi University at that time. One is that he wrote a research paper from human rights to right to be human. So right to be human, there he extended the Marxian doctrine of basic needs, that is fooding, clothing and lodging. The fourth factor he added was medical aid, and the fifth, education. So that's how medical aid becomes a fundamental right in Permanent Khatara case just after that research in 1886. And right to education becomes a fundamental right in 1994 to Unni Krishnan judgment. Then the constitutional amendment, Article 21A coming, and 2002, and then getting implemented from 2009 onwards. If one more thing we add, which I always say, right to employment or right to work, because if this is provided to people, right to work, then the first five needs human beings will be able to manage on their own. So from human rights to right to be human. Then another research was on doctrine of basic features. Just after the decision in Golaknath case of the Honorable Supreme Court, Professor Pradyumna Kumar Tripathi of Delhi University, the first Professor Emeritus from Delhi University from Faculty of Law, father of esteemed senior advocate Mr. Parag Tripathi in the Supreme Court, Professor Tripathi in fact said in his famous book, A Critique to Golaknath, he researched the doctrine of basic features, which becomes the majority judgment in Keshwanand Bharti case, and acknowledged accordingly. On that basis, only within a few days, Professor Tripathi was declared as Professor Emeritus for his great research. So, in this context, in the end, the basic features in one or two lines, if I say, they are the features which constitute the basic structure of the Constitution. So basic features, no list has been drawn by the court itself in 1973 judgment. Yet, from the analysis of subsequent judgments, we find that important basic features, of course, there are many, to my mind, rule of law, secularism, higher moralities of the Constitution, which I explained in Constitutionalist, Article 32 of the Constitution, Article 226 of the Constitution, 136 special permission jurisdiction SLP of the Supreme Court, then Article 137 review, from where the doctrine of curative petition comes, then 141 law declared by the Supreme Court to be binding on all courts, then 142 complete justice, then Article 121 that Parliament will not discuss the judicial conduct of judges in the Parliament or state assemblies. Similarly, 122 that courts will not intrigue themselves into the procedures followed in Parliament, doctrine of judicial review, and above all, the welfare state, the whole philosophy on which Indian Constitution rests, and that caused worry in my mind, the receding of human rights movement in backdrop, because then welfare state concept will go gradually in backdrop. With this note, I express my great regards and thanks to Professor Bhavesh Gupta ji and Professor Behel and Professor Navjot Suri, and also to NMIMS staff and faculty members across the 6 schools. Besides,
and we have some with our director. We have with us our director also, Professor Dr. Ravikant Swamiji. जी.
I express my
Mishra ji,
regards.
thank you so much. Mishra sir, thank you so much. And once I had opportunity to meet Mr. Bhushan, who was probably the first Vice Chancellor of your university.
Right, right. So it's Professor Y.K. Bhushan you are talking, sir. Professor Y.K. Bhushan of NMIMS.
Yeah.
Sure. Professor Y.K. Bhushan was a very, very acclaimed professor of this great university of the country, which is a leading academic brand across the globe now. And we have dedicated our 16 Bloomberg Terminals library and the whole library of NMIMS database library in entirety in the memory of Professor Y.K. Bhushan. So,
Navjot, you can go ahead if you have any questions or queries.
Sir, we have a question. It's not related to the topic as such, but then we are getting few questions that the value of webinar is similar to seminar, and do we have any API score on that?
this question, in fact, it's an academic question, but I can explain it.
Because
webinars are, in fact, online seminars, more convenient to everyone. And they are going to be the future of the country. And I'm very grateful to Prime Minister Modi ji for launching Digital India and digital balloons in the country 6 years back itself, and in Gujarat long back, which has given tremendous connectivity to academicians to connect with the students even in far off places where they are in lockdown situations. So far as this concept is concerned of API scores, gradually it is getting diluted, in fact. But definitely attendance in these webinars will matter a lot in the profiles of students for placement purposes and also learning purposes of online technologies and also of faculty members. And since there is no bar, they will definitely be added in the API score.
Okay, sir. So till the time we get more questions, we can have a break of 2 minutes.
Sir, good evening. Good evening, sir.
You can post your questions on the chat box. Kindly post the question on the chat box.
Najot ma'am, somebody is asking about the concept of judicial activism.
Okay.
All right. Judicial activism is in fact the problem in India is not of judicial activism. The problem in India, to my mind, is academic, executive, and legislative inactivism. And this judicial activism is a term floated by people who were mesmerized, who were awakened, who were shocked by the way things started developing from 1976 inwards. The politicization of governance, especially the Bhagalpur blinding case, when prisoners were blinded during emergency, jailer and staff told that we have brought Ganga Jal to clean your eyes, and acid was poured in the famous film Ganga Jal. That was the first public interest litigation in India, filed by father and mother of Madam Priya Hingarani, erstwhile Vice President of Supreme Court Bar Association, and Aman Hingarani. Like these two advocates, they filed the first PIL on the reporting of the great correspondent of Indian Express those days, the daring one, because there was press censorship on, and Jeevan Nair I'm referring, and then the first PIL comes, and that was also a concept, students, which was developed by American Supreme Court. The first trial of the world was granted in Al Jidon case. Facts of the case were almost similar as were there in Rudal Shah case of compensatory jurisprudence in Part 3rd in Indian Constitution. On the same basis, facts were common. So first trial in the world, this Al Jidon case. In India, it is Bhagalpur blinding. So if it was difficult for inmates in Bhagalpur jail to approach the court, and similarly people suffering from economic, social and other handicaps, it's very difficult for them to obtain justice, which is very costly. Filing of writ petition costs around 2 lakhs in the first appearance, and the advocate of the High Court and Supreme Court charge around 21,000 per appearance. So these
So
things
we have one more question, that
Sure.
personal laws are laws within the meaning of Article 13 or not?
Well, definitely, because personal laws also have the protection. The time has come, and with emboldening, when once the government and governance becomes strong in the country, judiciary also musters its strength, support it gets. Similarly, army gets support if the government empowers army. Similarly, the court is taking a view, the right view, that that the matrimonial matters and family law matters I'm sure will have the backing of the fundamental rights part of the Constitution in times to come.
And sir, importance of cooperative society in our Constitution. What is the importance of cooperative society in our Constitution?
Excellent question. In fact, the whole concept of cooperation and inter-state relations, the total concept of federal edifice, all these are excellent concepts and very important. In fact, unless and until the cooperative societies are there, we are not going to succeed. And just to mention here that the entire green revolution, blue revolution, yellow revolution, pink revolution, white revolution, they were not in government sector. They were all in cooperative sector or private sectors. And it's the contribution of individuals which can make, which has made and will make India a great country.
Thank you, sir. So I think we've already crossed the time limit. It was nice having you, and sir, I would like to express my gratitude towards agreeing to our request to be the speaker for this webinar. Now I would request Professor Dr. Bhavesh sir to please give the vote of thanks.
Thank you, Navjot. Thank you so very much. It was indeed a pleasure listening to Professor Dr. Alok Mishra ji, whom, believe me, he is an epitome, rather an authority when it comes to the Constitution. Thank you so very much, sir. It was a pleasure listening to you. That will be cherished a long time by all of us. And responding to each and every query to the utmost satisfaction of each and every participant was also a pleasure of all of us. Thank you so very much. I also extend my thanks to the director, sir. Ji, sir.
Dr. Gupta, I'm also very, very thankful to your esteemed director who devoted so much of time of being with us, and Professor Behel. And of course, you as a colleague, I had the occasion to work for so many years in leading law school of the country, Amity Law School, Delhi, one of the ranked law schools. For more than 5 years or so, I was there. Then I came to other places, and now building up this NMIMS group of institutions like schools of law. In fact, I'm very, very thankful to you for your dynamic leadership and giving me the opportunity.
Thank you, sir. Thank you.
These are the opportunities. Institutions are there. Institutions are great. We are the servants. We have to serve the students. We have to serve the institutions and seniors and all of you. In that context, with great humility, I express my gratitude to you, your team, and your authority who gave me this opportunity. And I congratulate you. Felicitations to you for doing so well for DME Law School and for all of us. You can continue with your.
Thank you, sir.
Thank you again, sir. Thank you.
Thank you, sir.
Thank you all the participants for participating. We are going to have series of webinars coming up in the month of June and July. So we'll be circulating all the details. I request all of you to please join these webinars. And that's it. Thank you so much.
Thank you, Dr. Thank you.
Okay.